Hi everyone, Harry here to talk about a different and troubling aspect of the Arizona case in which Jenna Ellis has agreed to cooperate. Lorraine Pellegrino has pleaded guilty. There is a document that came out yesterday that makes plain that the grand jurors wanted to indict Donald Trump, and Trump is referred to as an indicted co-conspirator all the way through. And the assistant attorney general handling the case says we know you guys would like to indict Trump, but we are not recommending it. And here's why, and I'll get to why in a second. Let me just sort of set up what's happened here. You recall that the indictment is divided between 11 defendants who are electors, local people in Arizona, and 7 Trump folks like Jenna Ellis and Boris Epshteyn and Mark Meadows and kingpin of them all, Rudy Giuliani. And the many of the state electors have said, hey, you just did this prosecution for political reasons, and therefore it should be dismissed under Arizona law. And the Attorney General, Chris Mays, has come in with a long filing saying, no, we didn't. In fact, we told the grand jurors again and again they don't have to do any filings, and we urged them, in fact, that not to do Trump, which would be the big political quarry to bag, and that didn't happen. So that's what sets it up. But now the actual guidance that was given. They're interested in Trump, and the Assistant Attorney General recommended that Mr. Trump should not be charged, citing a Justice Department policy that discourages bringing state and federal cases against the same defendant that are largely based on similar facts. Presumably, they're talking about the January 6th case. But the policy that the Assistant Attorney General is referring to, I think, has to be what's called the Pettit Policy, P-E-T-I-T-E, after a case in which it was brought. And among my nerdy attributes from working at the Department of Justice is the Pettit Policy was sort of my lookout. We rewrote the whole thing. I led the effort, and I'm here to tell you he doesn't understand the Pettit Policy. So the Pettit Policy says that once a state has brought, it says nothing at all about whether a state should bring charges. It doesn't attempt to discourage it in any way. There are other policies that the Department of Justice has that say, it's a good idea if a case could be brought in state or federal court to get together, talk with your state colleague, decide what would be the best, etc. And he seems to have confused, the Assistant Attorney General does, that kind of, good housekeeping guidance with a policy that is designed for the Department of Justice to be able to bring a prosecution after a state case already has been brought. So the whole premise of the Pettit Policy, where it applies, is that a state prosecution has been brought. That's no justification for not bringing it. And it's only guidance for the Department of Justice and what it should consider. And as you might, let me just sketch out the policy. If somebody's already been tried in state court, the law permits the federal government to retry them on the exact same facts. Has a kind of a smell and feel of double jeopardy, right? But under the law, the states are separate sovereigns from the federal government, so it's as if they were first tried in, Brazil and now coming here. In other words, as separate sovereigns, there's no constitutional bar. So the Department of Justice has this policy recognizing that the sorts of considerations that underlie the double jeopardy bar apply here. So when should you bring a case after the state already has done it? And the short answer is you should bring a case if the state prosecution, for whatever reason, left the federal interest in the case. And remember, federal government and state government have different interests in the case. Another reason that telling the Arizona grand jurors to stand down is just, a complete confusion. But you should bring it when the federal interest has been demonstrably unvindicated. Classic case, Rodney King, which I worked on the federal side. You had the Simi Valley prosecution. It had happened. It had ended in an acquittal, and the federal government's interest in the civil rights violation just hadn't been vindicated. You could have other cases in which somebody has a very light sentence and it hasn't been vindicated. Several kinds of things really could fit there, but you don't want to just do it willy-nilly, just pile on just because you can. The presumption is you don't bring that second case, but unless you can show that, the federal, you're here and you're thinking about the federal interest, which is what you do. You're a DOJ prosecutor, and that interest has been left unvindicated. So again, the Rodney King case, the perfect illustration. So when this assistant attorney general is telling grand jurors in the room, but you don't want to do this because there's a DOJ policy that says, basically saying, discouraging bringing state and federal cases against the same defendant, largely based on similar facts, that is at best, a very partial statement of what the Pettit policy is about. And in fact, the Pettit policy, possibly construed, had nothing to do with whether Arizona should have indicted Donald Trump. So it's a very strange situation. You can't go back now and, you could try to supersede the indictment. We'll see if there's pressure for that. But basically, the grand jurors wanted to indict, and they were, persuaded not to. And that's kind of the die is cast, and it's hard to revisit. But it looks as if it was based on a simple misunderstanding about DOJ policy that really had no bearing here. So bizarre and a little bit troubling, because in the proper application of the DOJ policy, we would today have 19 defendants, and the 19th would be Donald Trump, and that would have real serious implications, as, for example, the Fulton County case did, but a much simpler case, and the Fulton County case has gone away, and now there's no state case pending. So the Arizona case, which is just really rolling now and includes defendants who would testify potentially against him, Mark Meadows, most preeminent among them, has a whole different flavor vis-a-vis Donald Trump. So kind of a whiff in the grand jury, and that's sort of the way it goes. We'll see whether people kind of shine a light on this and try to revisit it. But as of now, we have unindicted co-conspirator number one, who otherwise could have been Donald Trump. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.